to explain some of these functions where there is need and whenever Parliament desires to get that kind of information. And I myself, as you know, I have been the greatest proponent of that process where, government functions and policies should be explained to the people's representatives on the plenary of the House, because that way you end up creating greater awareness than you could possibly even do through television appearances. So, Honorable Chairman, in response to the Honorable Gikaria's question, that's what I would say. Again, more and more robust engagement with the public. Finally, Honorable Chairman, the issue raised by the Honorable Mishimboko is a very serious one, because I know for the last almost 8 years, this is a matter that has, exercised the minds of, the legislature particularly, and various committees of the House. But I think if we implemented an integrated management system, legal management system of the magnitude of IFMIS, it means that anything happening in the smallest unit of government will have a way of getting to the Attorney General up in issue before action is taken, to avoid, and if indeed Parliament were to help the Attorney General's office to achieve this, it will be an extremely important achievement, because one, we will be in a way able to tame some of those underhand dealings that happen in ministries, and only later to end up in courts, government being sued, and in situations like the one the Honorable Mishi raised, threats being made by outside bodies. Thank you, Mr. Chairman.
Owen Bayer. I can see some soliciting through facials. Rahab Mukami. I'll give Naisula and Dawood. And wait for the next round. If you can also be as precise and concise as the last batch of 4, we'll make very good progress. Owen.
Thank you, Honorable Speaker. My question to the Speaker Emeritus, who is the nominee for the Attorney General Office, is that during your tenure as Speaker, we lost several laws at the judiciary. When they were taken to court, we lost them. Seemingly, these laws passed through the Attorney General's office from the Ministerial Cabinet and the journey into Parliament. Under your stewardship, we lost several of those cases, and they were termed unconstitutional. But we also used to call you in Parliament as the working dictionary of the Constitution, because you have every, but we lost several of them on the aspect of constitutionalism. How will this be cured so that Parliament is not embarrassed again in court? Secondly, if the chairman would allow me, there has always been this battle of which is the upper house, and your several pronouncements in Parliament indicated that the National Assembly is the upper house. Now that you are going to be vetted and become Attorney General, how will you cure the supremacy battles between the two chambers of the House? I thank you.
So what's the next?
Congratulations, our former Speaker. What I want to ask you, what strategies will you put in place to promote administration of justice, bearing in mind that majority of Kenyans cannot afford legal fees in the court?
Thank you. Next, Naisula.
Thank you, Chairman. To the nominee, former Chief Justice David Maraga is quoted having said that the government cannot demand of its citizens the obedience of the law if those in authority were disobeying court orders with abandon. As a departure from past practice, the Kenya Kwanza administration pledged to obey all court orders. The other day, the Public Service Commission advertised for the Chief Administrative Secretary jobs. LSK is already in possession of orders, but the PAC in its latest statement was categorical that the recruitment process will continue uninterrupted. There are indications that the current administration is keen to retain the positions so pre-election agreements can be honored through appointments. As the AG, what is your position on this matter, and especially on ensuring the rule of law is followed throughout and not only when it suits the government or the executive?
Thank you. Thank you, Chair. Chair, I'd like to ask, first of all, congratulate our Emerita Speaker on being nominee for AG. I would want to know, how are you going? One of the functions of the AG's office is constitutional implementation, legislative drafting, and the other one is legal aid, which you have already talked about, but I think we need still more what you have said to Honorable Gikaria, because a lot of citizens cannot afford legal aid, and if you can fashion something like the Citizens Advisory Bureau, which is in the UK, something on similar lines, which would be probably be based in Huduma centers or something like that. But my question to you, nominee AG, is the Constitution has been there, the new Constitution 2010. We still call it the new Constitution. There are many laws which have not been implemented to date, have not been enacted, or they are not being followed up. So you as the AG, what will you do to put into effect all the laws which are in the 2010? Because I remember I was in the CIOC and we left many laws which have not to date been implemented. So as the AG, how do you take that? And about the pro bono services, because this is a hustlers government. So we need pro bono services for the hustlers because they cannot afford it. The rich can afford their lawyers, and not just for criminal cases, even civil cases, because there are land cases which are there. People are being moved out of their lands and they cannot afford it, and the rich get away with those atrocities. So how are you going to assist them? Thank you.
Attorney General nominee.
Thank you, Mr. Chairman. And starting from the question raised by the Honorable Wandibaya, first of all, on the issue of upper or lower house, I want to say that my experience is that this is it's neither here nor there. It's a matter that you find in very many jurisdictions where there are two houses. And as you know, even when you're campaigning, there's always one person claiming to be better than the other. But the electorate will always make their decision. The roles of each house, in our case, are clearly provided for, so that the issue of which is upper or which is lower shouldn't even arise. It should be who is performing what role. You look, because both houses are parliament in terms of Article 93. The legislative process is clearly provided for in Article 94. Then the roles, specific roles of each house provided for in Articles 95 and 96, so that there should be no conflicts, and for me, the issue that was raised about the lower or upper house, I think should not even preoccupy us. If anything, I think it is diversionary. And sometimes we should leave it for people to enjoy. It happens actually even in other jurisdictions. If you go to London, you find about the House of Lords. The popular refrain there is that it is the largest regular gathering of retirees. So these things are always there. These are jokes, but when you check how the two houses operate and relate to one another, there is a lot of difference. So because everybody knows their specific area of operation. With regard to laws, let me say that there have been a few laws that have been part of them annulled. But really, the House's function is to make a law. It is the function of the judiciary to interpret. And I think we should not even feel unhappy, because remember, you have played your part. You let the judiciary go and play theirs to do interpretation. The area where there was some little bit of contention was with regard to the application of the provisions of Article 110.3 with regard to, the specific provision is actually quite testing, and I think it's a matter that and I don't want to go into a lot of details because, as you know, there's a matter pending before the Supreme Court, and maybe it would be a bit unfair for me to go into a lot of details. But you just need to look at the specific wording of Article 110, Clause 3, and see it creates there's some gray areas, because it says before any House of Parliament considers any bill, the two speakers of the National Assembly and the Senate shall resolve any question as to whether, one, it's a bill concerning counties, two, if it is, whether it's an ordinary bill or a special bill. So it's a matter that there's been some contention there, because when is a bill considered? Is it when it is published? Is it when it is read for the first time? Or is it when it is coming for second reading during debate? So I think that's a matter that I think it's only fair that we leave that to the judiciary to advise all of us, even though we also have a duty and obligation to interpret the Constitution, but the final arbiter must at all times remain the judiciary. The Honorable Mukami, yes, I agree with you that court fees are quite high, but remember now we are in a free market economy. And I sympathize with the situation whereby many of our people cannot afford the legal fees charged by our lawyers. But also, on the other hand, it is an truism that which we cannot escape, that whatever it is that the Attorney General's office can be given to address this issue, is only so much. And again, it comes from the National Assembly to decide how much you would want to give to the office of the Attorney General to pay for this. It's a very, very difficult situation, and particularly in civil matters, it will be so difficult to know, because people will differ about this. Maybe somebody wants to divorce, and they're saying that they are not able to afford the fees to divorce their wives or their husbands. Now, how is the Attorney General going to come to say to step in to come and pay fees for them? It's one of those things that it's like the chicken and egg situation. One, it's an issue that we sympathize with, that fees are quite high, but inappropriate public interest litigation, as you all know, courts, there are no fees charged. The Honorable Lesunda, Mr. Chairman, has asked a very interesting question about obedience of court orders. What I know is that there is a pending matter in the Court of Appeal on this issue of that same matter that the Public Service Commission is undertaking. There was a judgment by the High Court in that original matter, but there was an appeal filed, and in that appeal there was some conservatory orders that were issued, which the current administration felt should not be the situation, decided to follow the Constitution, because Article 132, Clause 4 permits the President to establish any office in the public service and make appointments thereto on the recommendations of the Public Service Commission. The issue which was raised in the earlier case was that there had not been public participation before the establishment of the office of Chief Administrative Secretary. So the current administration felt that they wanted the PSC to involve the public and advise the president. I'm not able at this point to know whether the advice has come from the PSC to the president, but so I can only comment to the extent that I am aware that, and I think almost everybody here knows that the Public Service Commission advertised for to the public for people to send views on the suitability or otherwise of the creation of the office of Chief Administrative Secretary. I believe there have been quite a number of views, representations made to the PSC, the results of which are not they are not with me, since I'm merely a nominee and I'm not supposed to know what it is that happened. And in any event, they were supposed to advise, as per the Constitution, the president. They are not even in doing that required. If you look at the specific provision, they are not even required to engage or involve the Attorney General in that matter, because it's up to them, once they have received views, to present to the president their recommendations. Finally, but therefore, let me just say this. I intend to advise the entire government that, the three arms of government, and indeed even the devolved units, yes, there is the principle of separation of powers, which is important in our constitutional architecture, but there is also need for each to respect the others. When Parliament makes a decision, the executive should respect that decision, and so the same should apply to judgments that have been given by courts. If there have not been any appeals, or even if there are appeals, they should be obeyed to the extent that an appeal has not invalidated the orders that may have been made. Finally, Mr. Chairman, there is the question raised by the Honorable Dawood, part of which is about on this issue of legal aid. See, legal aid must be understood to not just be limited to pro bono services. The Office of the Attorney General doesn't have the personnel, and I think will never have the personnel enough to give pro bono services to every citizen. The best that the office can do is to just give general information. And my position is, once we are able to roll out the services of the Office of the Attorney General to every of our counties, because currently we are only in 13, and that leaves quite some big part of the country without the services of the Attorney General. We can only do so much, because we are limited both to both the space, resources, both the human and financial. In several cases, like I said earlier on, it becomes very, very difficult for the Office of the Attorney General to really give free representation to citizens, because the range of disputes in civil matters is so wide. The Office of the Attorney General cannot possibly contemplate what is likely. Somebody will be saying this from Garissa, another one from Migori will be suing another one, and it's not possible. And not all the cases are against government. Some of them are disputes between citizens, both human beings and juristic persons. So it's likely to be quite a challenge to the Office of the Attorney General. With regard to the cases, the number of laws that have not been implemented or passed. Mr. Chairman, the challenge goes back to Parliament, because if you look at, although I can say here authoritatively, if you look to the 5th schedule, all the laws that were supposed to have been enacted by the last 2 parliaments, in fact 3 parliaments, have all been enacted. If you go to the schedule in the 5th schedule of the Constitution, all of them, without exception, were passed by the last 3 parliaments. So there isn't any that one can say has not been passed. I'm also, I can also say authoritatively that there are several others which were not in the 5th schedule, which, through efforts of individual members, have also been enacted. I know that Parliament was supposed to enact legislation to give effect to Article 100, and I'm aware that the last Parliament, I think the National Assembly had already done their bit and referred the bill to the Senate. Well, this is a new Parliament. I think that can be, the matter can be reopened. But I think I would want to enlist the help of the National Assembly in particular in combing through the Constitution and seeing which other areas of our Constitution may require legislative interventions, so that working together we can do it for the benefit of the people of Kenya. Thank you very much, Mr. Chairman.
Jonette, Koech, Raso, Mule. You'll all have an opportunity, don't worry. At one question each.
Yeah, thank you. Thank you, Mr. Speaker. Mr. Chairman, Honorable Attorney General nominee. My question is, you have served as the Speaker of the National Assembly for the last 10 years, especially under the new Constitution. You're the first Speaker who came after the new Constitution was promulgated in 2010. So 2013 was the first Parliament to implement. And as you are aware, the biggest problem with following the law, the Constitution, is normally with the executive. And for that matter, they will want to interfere with other institutions and other arms of government, like judiciary and parliament. What is your experience as a Speaker for 10 years? Was there a lot of interference from the executive? And as now somebody who's sitting as the Attorney General, what will you advise the government on how they should not interfere or not to deal with other arms of government? And also the issue of how do you intend to make sure the country is run by the rule of law and constitutionalism? That the executive is the one that normally has a problem with the law, as I've told you. So how will you make sure that they follow constitutionalism? An example, a point in case, as late as yesterday, is that the Constitution says, and I'm happy that's what the new government wants to implement. They were making the police service to be very independent and making the Attorney General, the AIG, have financial independence and those things. But yesterday, I came across an incident, Article 245. It says that the minister in charge of police can give police orders in terms of policy issues. But no any other person can give the police instructions on what to do. But the president gave them instructions yesterday to disband a unit of the DCI. Is that constitutionalism, Mr. Attorney General?
Congratulations, Mr. Speaker. Yeah, sorry about that. Congratulations, Mr. Speaker, on your appointment as the Attorney General. One is the courts ruled on the CDF, Constitutional Development Fund. Up to now, there has not been disbursement, even emergency. What is your interpretation on the ruling? And going forward, then, what will you, how will you guide the government? Thank you.
Aso,
thank you very much, Mr. Speaker. Honorable JB, congratulations on your nomination. if the House approves your nomination, you are likely to have worked in the three arms of government, maybe among the few. My first question is, what will haunt you is what you pronounce from the floor of the House, why the executive must respect the summons by Parliament. And you kept on saying severally. So that leads me to my question on the issue of extrajudicial killings and the disappearance of Kenyan citizens. This in itself is violation of human rights and the Constitution also. What are we likely to see under your watch as the state legal advisor? Thank you, Chair.
Mule.
Thank you very much. I want to say congratulations to Honorable Muturi. We have worked closely together on the TB caucus for 10 years. Mine is on two fundamental issues which lies with the Office of the Attorney General. That is the international agreements and the cases which are likely to bear direction from your office as the Attorney General, whereby we look at the case whereby Kenya lost to ICC on the Mediterranean border with Somalia. And do you intend to appeal or advise the government of the day on how best to resolve that dispute instead of going full throttle to claim the good stature? The second one is the issue of Migingo, which lies in that preview of the international borders of Kenya, whereby Migingo has gone silently and we are not aware as Kenyans at the end. And on the agreements, as Attorney General, there are so many agreements which have been sent to the Attorney General. Some of them have not been effected, like the agreement for Qatar for building affordable housing, which has been lying there, and then it elapsed and we lost almost 5 billion shillings as a country. And also the agreement between Kenya and Britain regarding the issue of Tuk in Laikipia, which really affects the interests of Kenyans and the interests of our international relationship with Britain. As the Attorney General, and if we approve you, how are you going to deal with these issues which are clearly within your office and advise the government the best way possible?
Yes, Honorable Muturi.
Thank you. Thank you very much, the Chairman. The Chairman, the Honorable Minority Whip, the Honorable Junaid Mohammed, raised the issue of interference by the executive and the issues of the rule of law and constitutionalism. But I think he directed himself, the intention was to ask the last question on the disbursement of the SSU. As I read it, I didn't know that there was such an outfit. But Mr. Chairman, every government is elected on the basis of some program and policy that it has to formulate when in office. And this government has clearly indicated that they want to get to be involved, particularly with Parliament, when dealing with issues of its policies. And for that reason that there is this request that Parliament allows cabinet secretaries to appear before the floor to respond. And I think this is again really just actualizing the provisions of Article 125. And being the people's representatives, I think Parliament should be kept informed of all decisions that the executive is coming up with. My view is that every arm of government should know what is required of it under the Constitution. The Office of the Attorney General seconds legal counsel to every ministry. And indeed, it is my position that I would want those legal counsel seconded to the various ministries to be the first point of call whenever the government is getting involved in any issues that have to do with the administration of the law and issues that touch on the constitutional requirements. But let me say, the president is the hand of the executive. And it is quite in order for him to use what has been said by his cabinet secretary, maybe quietly. It is quite open to the president to say it publicly that that he has instructed for this to happen. Remember, indeed, he is the foremost spokesperson of the government and indeed of the country. And therefore, I don't see any interference, so to speak, with the functioning of police. And I think we all must allow that from time to time, communication will be made which explains what government is doing with regard to various activities that are taken by various agencies. Honorable Koech, Mr. Chairman, raised the issue of the CDF ruling that came on the 8th of August. Quite an interesting date for the ruling to have come, because I was reading it as I was driving to the village to go and vote the next day, and it was a bombshell. But I think consultations are ongoing. It is agreed by many people that that what CDF has been able to achieve in this country is phenomenal, and I think we can be able to work on around ways. Remember, there were some areas that the court took issue with. One, the area of shareable revenue, so that we can address that one as Parliament. Actually, Parliament can address that one by going through, look at what is provided for in Article 202, so that CDF does not become part of that mechanism of sharing national revenue, so that what remains with the national government becomes the place where CDF should be hyped off from. So I think if we can consult on that area, I think we can make the necessary adjustments. And it's unfortunate that as a result, no disbursements have been made so far. I think it's really an unfortunate situation. The other area which we need to address, and I think this is within your powers as members of Parliament in the National Assembly, is what the courts went to great lengths to explain about service delivery. And I'm sure, Mr. Chairman, looking through these members, these are fairly clever members. We can deal with that. It's something that we can work on. And I'll be available. Because I truly feel that CDF should continue. On the issue of extrajudicial killings, Mr. Chairman, I think I would want to associate myself with the outrage that His Excellency the President, expressed yesterday. I think, being a country governed by the rule of law, we should never have a situation whereby, this is happening in our country. And from me, you can expect that we will be, advising the relevant agencies to be on the lookout that even this is a way of actually burdening the taxpayer, because those who lose their loved ones through these processes obviously end up suing the government. The government has no money of its own. That money comes from the taxpayer. And I think we also need to revisit, and I want to make a plea to Parliament, because I know you also make a lot of recommendations, that we need to bring back this issue of surcharge. Individuals must be surcharged when they they do things which are outside of their official responsibilities or duties that they are given to. The Honorable Mule, on the issue of international agreements, and I'm doing it very quickly, I will need to study the issue of the maritime dispute with Somalia, as well as the report that came from the committee that dealt with the issue of Migingo. I believe these countries being our neighbors is something that we can be able to amicably resolve. There's no need of going to war over such. And I think because I know there are some reports. There's some reports, and on this issue of the dispute with Somalia, I know there is a matter. There's a committee that is handling it, and I'll need to go through it and be able to make an appropriate decision. The same should apply to the issue of Batuk. They call it the British Army Training Unit in Kenya. I think the last that I know of, and I think Mr. Chairman, here we are lucky in that the Honorable Dido Raso was in that committee, and they know that they made some recommendations which were actually pending ratification by the House, but unfortunately the House went into Senate recess. So it was a matter that will be coming up to the House actually before for more ratifications. Yeah, thank you very much.
Our time is up, but there are members whom I can clear up with, Honorable Murugara, Posing, and Amisi. 1 minute each, please.
Thank you, Mr. Chairman, for my 1 minute. Congratulations, nominee to the office of the Honorable Attorney General. My question is this. Of late, we've actually seen the office of the Attorney General almost being mutilated, such that most of the agencies have been taken away from there, and maybe that is the reason why everybody believes it's losing color. Initially, even at independence, it had possibly all the departments, including prosecution, it had possibly the judiciary, and many others. We've seen the Executive Order number 1, which now vests the liaison between Parliament on legislation in the office of the Prime Cabinet Secretary. We are also told that soon you'll be losing the Asset Recovery Unit, because they believe it should not be anchored in office, should actually be with the anti-corruption. My question to you is, are there other areas you think we should be moving by way of legislation to bring back to your office, or even to add to your office, so that that color which is being lost is actually restored and your office goes back to where it used to be?
Thank you. Thank you, Chair.
Thank you, Chair.
Huh?
It was
okay.
It was him and myself, then.
Okay.
Yeah. Thank you, Chair, for this great opportunity, and congratulations, Honorable Speaker, for being nominated to the office of the Attorney General. Chair, this is a very fundamental question, the nominee Speaker. It was asked by Honorable Bayer, but indifferently. Chair, you've been the Speaker. There's been this problem between both houses, that is National Assembly and Senate, particularly on summoning of ministers by committees. You find that this committee invites a minister for this question. The next minute you see the same minister is being invited in Senate, even on issues that might not even be necessarily be for counties. And that, Honorable Speaker, is a very, very fundamental question, because it affects services to the people of Kenya. And even the Speaker, it becomes even more necessary now that there's a proposal to amend the standing orders to bring ministers into the House. So the question is, will the ministers go to National Assembly, and after leaving National Assembly, they go to Senate? Will there be any work, Honorable Attorney General, that will go on in this country? What will be your able advice? Thank you, Chair.
Thank you, Chair. Congratulations, our nominee to that office of the Attorney General. Your predecessor's time, there was a frosty relationship between the executive and the judiciary. You remember the judges were not appointed. Our case, AG refused to continue our case at the International Court of Justice. The Parliament dissolution was not obeyed, and many more. In a presidential system where we have the three arms of government, in your view, do you think this is a working system, or what is a lacuna, and how can you be able to cure it at that office? Because you have that advantage of having served in the three arms of government, the judiciary when you're magistrate, you've been the head of parliament, now you are going to advise the president. We have had this constant accusation and counter-accusation against the three arms of government. The executive does not obey the court orders. The judiciary is always annulling laws that are passed by parliament. Parliament is being accused of not funding the judiciary enough as a punishment. So it's always a squabble. How are you able to come in? Because you've had the advantage of serving both of you. We want to see change. In fact, you are the first politician to ever hold that office. Is Kenyans being hopeful in this, in your office, in your new tenure?
Yes, nominee.
So I say we've run short of time, Mr. Chairman. I'll do very quickly, but Mr. Chairman, allow me to inform the committee that I may be not the first person to serve in the three arms of government, knowing particularly the chairman himself began in the judiciary and has been in the cabinet. So that's maybe something that not many Kenyans are aware of. Yeah, I may not be the first one, but it's a good point. Let me go to the question by the Honorable Morugara, and it's a serious one. I don't think whether they really would be craving to have the judiciary being brought under the Attorney General. It suffices that the Attorney General is a member of the Judicial Service Commission, and from that position is able to advise on the issue of administration of justice. And also the fact that the Attorney General chairs the National Anti-Corruption Steering Campaign Steering Committee, which brings together the players in the justice sector, all of them. And without having to go to beginning to name all of them, that in itself places the office of the Attorney General in a very unique position to run many of the functions that the AG's office is supposed to be. Law reform. Now, you've just talked about the Honorable Murugara, Mr. Chairman, spoke about the asset recovery. Asset recovery is an agency that was created just the other day in 2009 when the Proceeds of Crime and Anti-Money Laundering Act was enacted, and its operations placed under the Office of the Attorney General. Indeed, if you look at the Executive Order number 1, it is still there. It is still under the Office of the Attorney General. I don't think whether the Attorney General would want now to ask Parliament to bring more of this. But as you know, the responsibility to assign implementation of various laws is under the Constitution given to the President. And actually, some of it, like you may recall, when you enacted the Marriage Act the other day, you placed its administration under the Office of the Attorney General. Parliament actually did that, which is within its power to do. So I believe that what perhaps we need to do is to bring in policies that bring the Office of the Attorney General to its rightful place. And for me, my view, Mr. Chairman, for instance, is that the Attorney General's office, the state law office, should be like a premier law firm. It should be the place where even citizens would feel, inspired to visit to seek legal advice. I believe that kind of position has been eroded over the years, partly because of inadequate funding, and in fact, Mr. Chairman, the recent complaint from the Office of the Attorney General has been that they lose they train, they employ, train state councils, and they end up losing most of them to, most interesting, Mr. Chairman, to Parliament, to the judiciary, and to the ODPP. That is a matter that really the Attorney General should be able to address. It cannot be accepted that people will move from the state law office to go and work in the judiciary merely because maybe the remuneration is better or the working conditions there is better, or go to the ODPP. But honourable members, because I will be making proposals on budgetary allocation, you just need to walk to that place. I have not been there, Mr. Chairman, for a long time, but when I went there, I wondered where it was that I was going to, because it looked like it's a very small place. But it is a place where there is so much that touches on almost every arm of government. Yet it has not received the kind of requisite attention that is necessary to give it pride of place. I will be pleading with members, particularly the National Assembly, to see to it that that the other place is elevated, and even to retain qualified and experienced professional staff, and people feel inspired. You should, if you went to look at where they conduct marriages, it's like a small cubicle that nobody would even want to sit there for more than 20 minutes. You feel that you might find the cockroaches around. It's very pathetic. Mr. Chairman, there was a question by the Honorable Kosing, member for Pokot South, on the summoning of CSs. I think there is no conflict, because Article 125 talks of either House of Parliament or its committees can summon any person to appear before it, to give information or evidence. Now, remember the argument, Mr. Chairman, which I have been raising over the years, has been when it says either House of Parliament. Where does the House of Parliament sit? It sits in plenary. It's because there was the issue of committees. So I think all we need to do is just organize ourselves a little bit well, so that everybody sticks to their mandate. I know the question being raised by the member for Pokot South is one that he has witnessed a lot of problems in dealing with. But I believe, Mr. Chairman, with you as a speaker, we will see a situation in which people stick to their lanes, so that what is for the National Assembly is the National Assembly, and what is for the Senate is for the Senate. But should there be concurrent, because there are those issues which are concurrent, the CSS should feel free to appear before both houses. Mr. Chairman, finally, there was a question raised by the member for Saboti, the Honorable Caleb Amisi. It's like, of this system, is it working? Is the presidential system working? I think, given that we've had this constitution for the last 12 years or so, it is still work in progress. But we should not rush to change or try to fix this or the other until such time as we have fully implemented everything under the Constitution itself. But I think it is possible for everybody to obey the law. The Honorable Caleb Amisi, Mr. Chairman, was concerned about the executive particularly not respecting the other arms of government, the judiciary and Parliament. But I want to say, well, sometimes it could be a matter of body chemistry. That maybe somebody felt that certain decisions were not favorable. But of course, the rule of law demands that whatever has been pronounced by the judiciary should be obeyed until annulled. If it hasn't been annulled, the executive has no option but to obey it. So the same should be, especially, and I intend to really ensure this is followed, reports of parliamentary committees, because if we don't implement them, then it means that we are wasting taxpayers' money getting committees of the House, and the House coming to adopt those reports and make certain findings. I think it's only fair that there should be a mechanism. I know in the past there used to be something which was called Treasury Memorandum on implementation of past reports. I think we should go back to that so that Parliament also is seen to be, so that whatever it is Parliament does is not seen to be acting in vain. If Parliament has recommended something, I think it's only fair. If the implementing agency thinks that there are difficulties, they should again appear before Parliament to explain those difficulties or why they are not able to implement what Parliament adopted. Thank you, Mr. Chairman.
Thank you, Honorable Muturi. Can I ask you one simple question? You and I have a history of having been magistrates, and when we were, you may recall, at 9 on the dot, you are on your bench. 2 on the dot, you are on your bench, dispensing justice to the public. Today, probably the only institution that keeps time in this country is Parliament. You go to court, your case is set for 9. By 11, there is no appearance of the judicial officer. Sometimes it gets to 1, you are told try at, you don't even come for the case, you try at 3 or 4, and then eventually a clerk comes to announce to you that the judicial officer is unavailable. As a member of the Judicial Service Commission, what is going to be your engagement with the judiciary to ensure that we go back to the old working days and times? Because justice delayed is justice denied. And if you tell a litigant to be at the court at 9, they also budget for their time. That they'll be there at 9 and go to do something else. Then you just come and sit and yawn at the law court from morning to evening and go back home without your case being attended to.
Thank you, Mr. Chairman. I think, and you put it correctly, and I'm sure all these members are aware. I think it's only Parliament. It's only Parliament that is known to observe time, particularly in plenary. Let me emphasize, particularly in plenary. Mr. Chairman, and my position has always been, which is in the standing orders, that if for one reason or other a committee has not been able to start 30 minutes after the appointed time, you just disband, you adjourn. In the case of courts, I think it is something that we really must work as a policy, that in fact, being late, and during our time, as you've rightly pointed out, Mr. Chairman, if we were late by even 10 minutes, when you appear, the first thing you said was to apologize to the assembled litigants and counsel, because you always felt it was, you have done something so abominable that you want to apologize to the people in the court. Today, as you rightly said and have observed, that has disappeared. I think Judicial Service Commission should revisit those because these are just standards really. And we talk about backlog of cases. Some of it, the contributor is this non-appearance by judicial officers or lateness. I think there has not been sufficient monitoring of the conduct. In fact, we would call it the conduct of judicial officers when dispensing justice. And that, in a way, has contributed to both, with respect, sometimes you look at the quality of the output and you wonder whether the people the people making those decisions are really vested in the same institutions as you and I did. And it's a matter that I intend to, again, it's just to make suggestions because it's for the betterment of this country, it's for the good of the entire country. And I agree with you, Mr. Chairman, justice delayed is justice denied. We, judicial authority, again, judicial authority is derived from the people. And the judicial officers cannot imagine that they are supposed to lord over them. They derive whatever authority from the people. That's in Article 159. Thank you, Mr. Chairman.
Thank you, Honorable Justin Muturi, nominee for Attorney General. I'll now avail you 3 minutes to make your final appeal, if any, to this committee.
Mr. Chairman, first of all, I want to thank you and thank the members of this committee. I think this has been a very useful engagement, and if approved, honorable members, I promise and undertake to do my best to give the best available advice to government, both at the national level and at the council level, in a collaborative way, as provided for in the Constitution, in the form of independent but interdependent. Thank you very much.
You are released to go, Honorable Muturi.
Thank you.
Thank you very much.
Thank you.
Honorable members, as the nominee exits, we will resume we'll break for lunch for exactly 1 hour. It is now 1 o'clock. We resume at 2 o'clock sharp. Leave your files where they are. The sergeant at arms is instructed to ensure the room is secure and no document of any member is found to be missing when we come back. Thank you. 2 o'clock.
Na mtazamaji, kama unavyotazama kikao cha pili au ile zoezi la kupiga msasa ya mmoja wa wale ambaye vile vile wanatafuta kuwa katika baraza la mawaziri au kuweza kuhudumu katika serikali, bila shaka ni aliyekuwa spika wa bunge la kitaifa Justin Muturi amekuwa kwenye kikango akielezea kamati ya watu 15 ambao wametwika jukumu la kuwapiga msasa jinsi atakavyotekeleza wajibu wake iwapo jina lake litaweza kupitishwa, na ameweza kuulizwa maswali chungu nzima kuhusiana na ofisi hiyo muhimu zaidi ya serikali. Kumbuka kwamba jina lake likipitishwa basi atakuwa mmoja wa wale ambao wameingia kwenye daftari za kumbukumbu kama mmoja ambaye ameweza kuhudumu katika hasasi 3 za serikali, na kwa hivyo ameulizwa kuhusiana na jinsi atakavyo shughulikia masuala ya kumrundiko wa kesi. Yeye kama mwanachama wa tume ya huduma za mahakama vile vile ameweza kuulizwa jinsi atakavyo hakikisha kwamba kesi za serikali hazishindwi kwenye mahakama, na akasema kwamba si lazima kesi iweze kushinda, na vile vile ameulizwa kuhusiana na swala zima la mauaji ya kiolela na vile vile kutoweka kwa watu, na akaweza kuweka paruanja jinsi atakavyo kabiliana na swala kama hilo, na vile vile swala zima la kuhakikisha kwamba masuala kuhusiana na wananchi kutafuta haki, kutokuwa na mawakili, uwezo wa kuweza kuwa na wakili, basi ameweza kuzungumzia swala hilo. Kwa sasa nitakurejesha studioni mwenzangu Troy Njue aweze kuchanganua masuala haya kwa lugha ya Kinginge, kisha atakuwa anarejea kwetu kwa mambo kuhusiana na masuala ambayo yataibuka hapa. Kumbuka kwamba watakuwa wanarejea mwendo wa saa 8 ili kuweza kumpiga msasa vile vile Aden Duale ambaye anatafuta kuhifadhi au kuweza kupewa nafasi kuwa waziri wa ulinzi. Kazi kwako Troy Njue.
From County Hall, and indeed it is the first day of the vetting process, and because of the interest of time, I'm just going to rope in my analyst of the day, Torsten Alenga, to give us a brief of what has just transpired after Justin Muturi is done and dusted, and early on we had Cabinet CS, Prime Cabinet CS Musalia Mudavadi. In a nutshell.
Yeah, I think the vetting process is going on properly. You can pick some legitimate questions being asked by the members of the committee, and we hope through that then the nominees will be able to clearly iron out issues that maybe pertain to their integrity as well as their capacity